we've gone through the Articles 1 through 3 of the Constitution so far. These were the three branches of government. So Article 1 is the legislative branch or Congress. Article 2 is the executive branch or the president. And then the third one was the judicial branch that we did last week. So this week we're going to do Article 4, and I'm hoping on next week's show I'm going to be able to do the rest of the articles, which are 5, 6, and 7, because they're fairly short. And then after that we'll be getting into the amendments to the Constitution. So let's go on with Article 4 now. So this deals with relations among the states. So as I mentioned before, the federal Constitution here, a lot of it is talking about the federal government, right? Not the state governments. Now, the state governments are mentioned periodically throughout the Constitution. And this is one of those spots. And actually, this one, Article 4, deals a lot with the states. So this one's a little bit different than the rest of the articles. So remember, though, that states have their own, state constitutions, and they have their own state governments. But this is an article where the Founding Fathers wrote some things about how the states are basically supposed to cooperate with each other on certain things and with the federal government. So this article has 4 sections in it. Section 1 is commonly called the Full Faith and Credit Clause, even though it's not a clause. It's just Section 1 in Article 4. So here's what it says. It's pretty short, but it's an important part of the Constitution when it comes to the states. So it says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. So that's the full faith and credit clause. So basically what this section is talking about is that states are required to respect each other's laws, records and the public records, and judicial decisions. Now, there are some exceptions, though, because you notice that the second part of that said Congress can make rules concerning this. Well, there are some things that Congress have done over time. So, one of these examples is that the states don't have to enforce each other's criminal code, for example. So let's say that I go down, like I live in Minnesota, and I go to Tennessee, let's say. The state of Tennessee, if I commit a crime, they don't have to enforce Minnesota's criminal code against me. They can enforce Tennessee's criminal code against me, but not Minnesota. So that's just an example of how states don't have to enforce everything from another state. But if it deals with records and judicial decisions and some laws, then they are supposed to. So one example of this is like divorce decrees. So if I get a divorce in the state of Minnesota, the state of Minnesota courts grant me a divorce, and let's say I move to South Carolina. The South Carolina state is supposed to recognize that I am divorced, and they're supposed to enforce the Minnesota divorce decree, at least initially in that state. Now, at some point, if there's a state of North Carolina action filed, then they may change the Minnesota court decision. But at least initially, they're supposed to follow the state of Minnesota's divorce decree. So if it relates to the property division or child support or stuff like that or custody, they're supposed to follow it. Or if, let's say, I get a judgment against somebody in the state of Minnesota for $100,000, they leave, they go to Georgia, I can file my judgment in the state of Georgia, and the state of Georgia is supposed to help me enforce that judgment against that person. So those are some examples of what these public laws, records, and judicial decisions mean, and how the other states are supposed to follow the first state's decisions here. Now, how you do that is, if I wanted my judgment to be enforced in another state, I have to get what's called a certified document, at least that's what it's called in the state of Minnesota, where the old state, I'll call it, usually they put a stamp on a copy of the legal document that you want, and then they put their initials on it and stuff, and they say that, this is a certified document, this is a true and accurate copy of the official court record in, whatever county they're in the state of Minnesota. You have to pay for that typically, although if you meet some financial guidelines, you can get it for free, but usually you got to pay for that. And then that's the document that you send and file with the new state. So that's kind of the process for how you do that. But some of these are not always followed if a new state creates something specific that they won't recognize. So, for example, this happened with gay marriage. Initially some states allowed gay marriage, some states didn't. Before we had the Supreme Court decision that made it legal nationwide. Remember, that was a Supreme Court decision. That wasn't something Congress did. So there were some states that passed laws saying they're not going to recognize gay marriages in their state. Or they're not going to recognize gay marriage divorces in their state. So at some point I thought maybe this was going to go up to the Supreme Court for a decision, and it never really did. So, but the Supreme Court decision that legalized it basically took care of that issue. So there are some times where states can pass, laws that maybe they won't follow certain things from other states. But generally speaking, each state is supposed to give full faith and credit to another state's laws, records, and judicial decisions. So that's what Section 1 deals with. Section 2 is about treatment of citizens. And this one has 3 clauses. So Clause 1 is called the Privileges and Immunities Clause. This says that citizens of each state shall be entitled to all privileges and immunities of the citizens in the several states. So basically what this means is, if you are a citizen, now that's the key point here. I'll talk about this later when we cover the 14th Amendment, but this only applies to citizens, not non-citizens. Okay, this is a key legal distinction, so just keep that in mind here. So every citizen has the same rights and privileges in any state they happen to be in, basically. So if let's say I go to North Dakota, and I'm a citizen of Minnesota, and I go to North Dakota, I'm supposed to have the same rights as every other North Dakota citizen. Now, there are some exceptions to that, like sometimes there are residency requirements before you can, file for divorce, for example. Many states, you got to live there for 30 days before you can file for divorce. Or, maybe other legal actions. But in the United States, you are a citizen of the United States, plus you're a citizen of the state that you live in. Plus, when you go, visiting or you live somewhere temporarily, you're also a citizen of that state. So, again, this only applies to citizens, though, not non-citizens. So, Clause 2 deals with extradition. Now, I'm going to paraphrase this one because it's kind of a long and a little more complicated clause here, but this deals with criminal law. So let's assume that a person is charged with a crime in State A. They run to State B and they get caught in State B either because they committed a crime in State B or there's a warrant, a felony warrant out them that's enforceable in all the states of the United States, and they get caught for that. So that person can get returned back to State A if the executive authority, which is usually the governor's office, of State A demands it. So here's an example. When I was a prosecutor and I found out that somebody that had a felony warrant in my jurisdiction, was caught in another state, let's say Wisconsin, I would need to send paperwork to the Minnesota governor's office asking that he make a demand to Wisconsin to let us bring the defendant back to our jurisdiction to deal with the charges that we had. Now, they still have to face charges in another state if they're charged with a crime over there, too. But they bring them back to the state of Minnesota. So the governor's office in Minnesota reviews, the paperwork that I sent in, and, at least when I did it, there was never a question. They sent it on to the other states, so let's assume Wisconsin here again. And then Wisconsin's, that would typically be in the Wisconsin governor's office, and they would notify the court, wherever that person is. Now, the defendant is entitled to what's called an extradition hearing in the state of Wisconsin, in my example, where they can go in front of a judge in Wisconsin and say, well, I'm not going to contest, that I need to go back to, the state of Minnesota. So they just have a hearing and the defendant says, I'm not going to challenge this, so off they go. Or sometimes a defendant does challenge extradition. And if that's the case, then the judge in Wisconsin ultimately has to make a decision as to whether or not he's going to force, essentially, the defendant to go back to the state of Minnesota, which most of the times they do, unless there's some real strange kind of factual thing or some legal issue that the judge says, well, we got to look at this more closely, or there is some sort of violation. But that rarely happens. These are usually granted. So that's what extradition deals with. So Clause 3, now Clause 3 is no longer in effect. This was about fugitive slaves, one of the few places slavery was talked about in the Constitution. So remember that this was drafted in 1787, right? And slavery was part of our society back then. So this clause was struck down by the 13th Amendment that got rid of slavery. But basically what Clause 3 was is that, and I'm paraphrasing again, that states had to return slaves that fled to another state. So they had to send them back. But again, that 13th Amendment got rid of this part of the original Constitution. So Section 3 is about admission of new states. So Clause 1 is the process for how this is done. Basically, new states are admitted by Congress, a majority vote in Congress. Now they have to do a bunch of, they have to satisfy a bunch of requirements and, paperwork and all this stuff to get it in, up for consideration. But Congress is the one that admits new states by a majority vote. So there's movements going on right now to try and get Washington, D.C. and or Puerto Rico to be a new state, which would presumably help the Democrats because you would get 2 new senators from each of those and at least 1 House of Representatives members, but in Washington, D.C. you're going to get more than 1. And I'm not sure about Puerto Rico, but that's based on their population. But that would help the Democrats, right? So there are a couple of restrictions here, though. So a new state cannot be part of an existing state unless the state legislature agrees to the change and so does Congress. Nor can 2 or more states merge into a new state unless the effective state legislatures, all of them are involved, agree and Congress agrees. Nor can parts of 2 or more states merge unless the affected state legislatures agree and Congress agrees. So other than that, that's how states get to become new states. Congress basically has to do it. Clause 2 is about public lands. So Congress has power over public lands. Now this deals with federal lands. This is not state lands. This is federal public lands. And also federal territories. Like, for example, Puerto Rico is a territory right now. So Congress can make laws, rules, and regulations to deal with this. So sometimes you hear about this when, like, Congress is debating whether or not to let oil companies drill for oil in some of the federal lands in Alaska, for example. And this is why they're debating it in Congress, because Congress has the power over federal lands. Finally, Section 4, this is the part where the United States, so the federal government, guarantees to all states a Republican form of government. Now, by Republican, that doesn't mean the Republican Party. That means the Democratic Republic, form of government where, you elect representatives and, you have Congress and the president and all that sort of stuff. That's what they're talking about there. So all new states who want to be new states, they have to agree to that form of government. The United States government protects these states against invasions from foreign invaders try to come and conquer them. The federal government will help with that. Also, if state legislatures ask, or the governor asks if the state legislature is not in session, they can ask the federal government to protect them against domestic violence under Section 4 here. So that occasionally happens. So this was kind of coming into play when after the George Floyd murder and some of the stuff the Republican Party was trying to pull at that point. So new states have to agree to our form of government before they can be admitted. And that's part of the process that they got to agree to before Congress will even vote on it. So that is Article 4 of the Constitution. So now we're done with that. And again, hopefully next week we do 5, 6, and 7.